It's a pleasure to be here and actually to be able to set the scene on data protection, because there was a data protection life already before the GDPR, and this is what I'm going to speak about. So it's a good introduction. I work in Strasbourg in the Council of Europe, international organization defending human rights, democracy and the rule of law. And the big difference with the EU is that we have 47 member states, so already a geographic spread which is big, and we're celebrating our 17th anniversary. So let me start by making an obvious and direct link between the work of the Council of Europe that I will be presenting, that's our convention, Convention 108, and the GDPR. And so Twitter, which is the most powerful source of information those days, tells us, and it was the tweet of a high official in the European Commission, Martin Selmayr, who at the time was the head of office of the President of the Commission, and he said that Convention 108 is the mother of the GDPR. So there you have the DNA and the filiation between those European instruments which is set. I may maybe just highlight that I'm not sure it's the mother, it might be the grandmother. Convention 108 is 40 years old, and before the GDPR there was already a directive, Directive 95/46, so that's the link. What I want to highlight is you see that this tweet was done on 28th of January, 2 years ago. And this is because Data Protection Day, which is celebrated worldwide on that day, 28th of January, is actually the anniversary of Convention 108. It's the date the convention was opened for signature in Strasbourg in 1981. So, as I said, maybe Convention 108 is rather the grandmother of the GDPR and would be the mother of the Directive of 95. And in the directive, you actually find this direct link between the instruments. It was there in a recital of the directive, in recital 11, which clearly stated that the directive gave substance and amplified the data protection principles laid down in Convention 108. So this was stated clearly. It's not as much the case now in the GDPR, I will come back to it later, but you don't have this explanation of the evolution of the regime and where the EU data protection regime comes from. So a general presentation on the convention. As I said, it was open for signature in 1981, so you see nearly 40 years old instrument, but still highly relevant. Why? It was conceived and thought already as a unique instrument. It was 40 years ago and it's still today. There is no equivalent at global level. There is no UN treaty on data protection. You have some regional instruments in data protection. If I take the African Union Data Protection and Cybersecurity Treaty, it is an international treaty, but it's not open to any country in the world. The convention is. It's been influential, so based on this 1981 set of core principles, you have had national legislations developed in many of the member states of the Council of Europe, but also at regional level, like precisely is the case with the EU framework. So, where are we today with this convention? Throughout the years, the Council of Europe has first started to really promote it with its member states, and then gradually realizing its global and universal potential and promoting it outside Europe. So you see, today we have 44 countries, it's 54, sorry. It's not actually correct the day of today, because 54 will be as of the 1st of June, when Argentina will effectively become a party. You see, we have 47 all member states of the organization that are parties. In terms of non-European countries, the first one was Uruguay, joining in 2013, And it was an easy pick, I would say, because Uruguay was also going under the adequacy regime of the EU. And then gradually, influence, you see Latin America, Mexico, that was in November, Argentina just deposited, I mentioned it, and it will come into effect on the 1st of June, but also the African countries, Cabo Verde, Mauritius, Senegal, Tunisia, and there you see more Francophone countries, because with the network of Francophone data protection authorities and the strong influence that some Francophone DPAs have had in the adoption of data protection law in Africa, there's been a spread of those core data protection principles in Africa. We also have pending 2 countries that have been invited but have not finalized their accession procedures, Burkina Faso and Morocco. And what is also important to note is that the convention, which establishes a committee meeting in Strasbourg twice a year, also enables the participation of observers, and you have the list of observers there. And you see that with the observers, we have all regions, we have Pacific, Asia, North America, and the African and Latin American countries I was mentioning. So 70 countries meeting every year in Strasbourg, represented by data protection experts, so it's either data protection authorities or governmental representatives for countries which do not have laws, which was the case of Indonesia when it started to work here with us. So it's a pretty balanced mix of experts coming and interpreting the core principles of the convention and setting standards in data protection for all those countries. So really a significant role today. The convention was conceived since the beginning in the late 70s as a tool to facilitate circulation of information. You find it in the text of the 1981 documents. The objective was to enable the flow of circulation of data. This is even more important and acute today with the ubiquity of data flows. And the fact that through this convention, we create a common harmonized legal space, a trust, and then a reciprocity in the exchanges. That's the core, that's the essence of the convention. So I've been speaking about this 1981 instrument, which was designed at the time where the technologies we're using today did not exist. So in the past years, as the EU has been doing, as the OECD has been doing with its 1980 guidelines on the right to privacy, the Council of Europe also decided to tackle the modernization of its instrument to make it fitter to the challenges we're now facing. So reinforcing the protection of the individual, but also on an institutional point of view, we decided to reinforce the implementation of the convention, because despite the fact that it's an international treaty, that countries are committing to respect the principles of the convention, we've actually realized that it was not always the case, and that if you want to provide a credibility to the instrument, which is essential for data flows, international data flows, you need to secure that this level of commitment, the provisions to which each state is committing, that they're actually abide by and respected. So we will put in place with the new convention a monitoring mechanism to be able to assess the compliance by the parties to the provisions of the convention. In modernizing the convention, we've made sure that we would be able to continue to promote the standard as a universal one. And so you can imagine that negotiating a treaty at 50 countries and making sure that the language is a language that would speak to any legal system was not an easy task. We had to preserve its simple and general nature. You have the text of the convention with you, and you will see that it's pretty readable. There is no reference to any buzzword or any terminology of a moment or of a technology. And one key point in the modernization was to ensure and to maintain, because it was the case, to ensure the consistency and the compatibility with other legal frameworks, and in particular, the framework of the EU. So Here we are 7 years, well, it was the case on May, 7 years after the initiation of the work. The work started in 2011, and you see it was a similar timing for the OECD work and EU work. And we delivered a modernized text on the 18th of May. That was the date of adoption. And then the amending protocol, because it's the form of this legal instrument, the amending protocol was open for signature on 10th of October. So why did it take us 7 years to achieve this, apart from the complexity and difficulty of negotiating an international instrument? The necessity of ensuring compatibility with the EU framework made us delay the work. We had to stop at some point. We were actually asked to put it on hold for the text of the GDPR and directive to be set. I give you an example. The criteria applicable to consent, whether the unambiguous qualification of the consent was decided in Strasbourg and yet not in Brussels, was an issue. So we had to wait for this particular criteria, for instance, to be set, and then to move along to make sure there would be no margin of interpretation that would be negative between the both texts, which is crucial because I told you our 47 member states, that's 28/27 member states of the EU, are bound by the EU framework and by the convention, so we could afford no discrepancy between the texts. It took us a while, but in the end the result is there, and it's an excellent result. Now I'm going to dive into the articulation with the EU framework. This is a recent decision by the European Parliament. The EU and the Council of the EU needs to authorize the member states of the EU to ratify the Modernised Convention, and for that there was an assent given by the Parliament. So the next step is that the Council will be now making this decision, I think shortly. I see Christina there who can comment on this. And so from that point, from the moment the Council has made this decision, the member states of the EU will be able to ratify. They've already been authorized to sign, and a number of them, not all, have already signed the amending protocol, but the next step is the ratification. And what is important with this screenshot is really how it's highlighted that the convention from an EU perspective and EU member state perspective is an important tool in the circulation of data. So before that, already in 2017, the Commission issued a paper, a strategy on international data transfers. You have the reference there, which really highlights the value of Convention 108 and how it can be used from a EU perspective. So the first thing is that in this document, the European Commission states that all third countries are encouraged to accede to the convention, that the Commission supports the swift adoption of the modernized text that was in 2017 since it's been adopted, with a view to the EU becoming a party to it. This is one of the novelties of the modernized text. It's also that the EU and other international organizations can accede to the convention. The Commission states that the Convention, with the EU data protection rules, contribute to a convergence towards a set of high data protection standards. So what about the precise articulation with the GDPR? I mentioned to you, quoting the recital 11 of the directive, that the link was really made obvious between the two instruments. With the GDPR, it's not so clear, but you find in recital 105 an express reference to the convention, so you have to place yourself under chapter 5 on international data transfers and article 45 of the GDPR. Article 45 concerns transfers on the basis of an adequacy decision taken by the Commission, and there in paragraph 2 of article 45 it is stated that when the Commission is assessing the level of data protection of a third country, one of the elements that has to be considered that can be considered is the international commitments taken by that country. So that's the text of 45 paragraph 2, and then you make the link with recital 105 that tells you that one of those international commitments is accession to Convention 108. So Convention 108, now we should read Convention 108 plus actually, is one of the elements considered in the assessment of an adequacy level of data protection, but it's not a conditional element. So you see, for instance, with the latest adequacy of Japan, that Japan is not a party to the convention. It did not preclude Japan to obtain this adequacy decision. Speaking about the adequacy, because it's the link, it's the articulation between the convention and the GDPR, let me now point out to the criteria on which this adequacy decision is being made. The assessment is based on this adequacy referential, which existed already at the time of the Article 29 Working Party and was revised, you see, earlier last year, and applied as criteria under the current regime. So in this document, you find something which is quite interesting. It's said that this is the first part, chapter 1 of the document, but that there will be a chapter 2 that will be worked in the future, which is about applying the approach, the adequacy approach, to countries that have ratified Convention 108. So this does not exist yet, but I think it will be very useful, and this is something that we should be working on in the future. But let's already make ourselves a kind of assessment of what you find in this adequacy referential and Convention 108 plus. And you see that what you have in the document for the part of content principles, so the definitions, the condition of legitimate data processing, of quality of data, the higher protection for sensitive data, the security obligations, the transparency obligations, the rights of the data subjects, and the rationale of a transborder data flow regime, this is all in Convention 108 plus. So all those content principles that you find in the adequacy referential are met by Convention 108 plus. You also have in the document additional obligations. You have conditions relying to sanctions and remedies, to supervisory authorities, and the recourse of the data subjects. Those are the procedural and enforcement mechanisms. And those two you find in Convention 108 plus. The last part is about the essential guarantees in case of processing by national security and law enforcement. That's the exception regimes, and this is clearly one of the key strengths of Convention 108 plus. Why is it a key strength? Because Convention 108, already in 1981, and this has been reinforced in the Modernization, is an instrument that applies horizontally. Its scope is open to and applies to data processing in the public and private sectors. So for some of the EU institutions in police or judicial cooperation, Convention 108 and Convention 108 plus is key, and I've just mentioned, for instance, a bilateral Eurojust and Albania agreement, which has been signed and which refers to the fact that Albania, being a party to Convention 108, provides safeguards in the field of public sector processing of this type. So just a point of focus now on this article on the exceptions and restrictions, because the right to data protection is not an absolute right. It needs to be balanced with other rights. And this is Article 11 of Convention 108 plus. And you see the criteria, which are criteria of the European Convention on Human Rights, which are extremely strict and on which you can come and limit the right to data protection, are taken in Article 11. The first criteria is that the exception needs to be provided for by law, and then there is abundant case law of the court on what this responds to. That it needs to respect the essence of fundamental rights and freedoms and constitute a necessary and proportionate measure. And then for specific legitimate grounds, you have them mentioned in smaller font, protection of national security, defense, public safety being one of them. I'm not going to list them all, you have them. What is also actually important to highlight is the balance with other fundamental rights. That's the last part on the screen. But what I wanted to highlight here is this text relating to processing for national security, because it's one of the advancements of Convention 108+ with a new paragraph, paragraph 3 of Article 11, which specifically deals with this type of processing and brings further safeguards. So you have the text there that really precisely lays down to which provisions of the Convention exceptions can be brought. But what is really important to highlight is that if a party makes uses of those exceptions, then it needs to be, in any case, without prejudice to the requirement that this type of processing for national security is subject to an independent and effective review and supervision. So this is actually really crucial when promoting Convention 108+ outside Europe, where, for instance, the European Convention on Human Rights Safeguards do not apply. We have it here embedded in Convention 108+. So the other clear articulation with the GDPR I had mentioned was relating to international data transfers, but what I wanted to highlight is from a Convention 108 party perspective, because we have had actually a conflict of regimes. We have a 1981 instrument telling us that there needs to be a free flow and free circulation of data between parties. And then you have an EU regime saying, no, EU member states, you cannot export outside EU countries. So if we take the example of Belgium, and if we take the example of Tunisia, of Ukraine, we have a restriction applying to a party to the convention. And this had to be reflected in the modernized instrument. We had to translate the fact that EU member states have this restriction, and it's there on the screen, the second hyphen you read, which is not that crystal clear, so we need subtitles, but a party bound by harmonized rules of protection shared by states belonging to a regional international organization means EU member states. I'm not diving into all novelties of Convention 108+, but I think really one important point also from an EU perspective is the new article, and there's actually a whole new chapter on cooperation, reinforcing the cooperation between DPAs. And so it's key that in the future, the DPAs internationally will have a legal basis enabling them to work together. And this is provided with Convention 108+ also. And you see, there is a possibility to coordinate investigation or intervention, or even conducting joint actions between the parties to the convention. That will be certainly very useful. So how was this possible, this evolution from Convention 108 to the directive and to the GDPR? Well, you have an article in the convention since the beginning that allows, at national level or regional level, like it was done for EU member states, it's possible to go towards an extension, towards broadening the scope, the protection. This is what was done by the EU. And just the three dots that are there are things that you will find in the GDPR that you will not find in Convention 108+. Because precisely there the EU has been going further and bringing new rights on. For instance, the right to data portability, you will not find it in Convention 108+, or the possibility to have a collective mechanism of redress for data subjects. So let me now come back to the beginning about this open and universal nature of the convention, which was wanted since the beginning and which is now really materializing. The special rapporteur on the right to privacy of the UN, Joseph Kanatachi, end of last year and again reiterated this year in March, he calls all UN member states to ratify Convention 108+, because there is no equivalent, because it sets solid universal ground and harmonized level of data protection. So this is a very strong call at a global level for Convention 108+. Convention 108 and Convention 108+ provides the backbone. It's the skeleton where you have really the core principles. But then the committee of the convention has been working on a number of sectoral instruments. Those 70 countries that are meeting in Strasbourg, as I said, are developing normative instruments. It can be guidelines, recommendation, opinions. And there on the screen you have the latest instruments that were worked on by the committee. The guidelines on AI and data protection, and you will have later today at the last session a presentation by Alessandro Mantelero. And Alessandro Mantelero, Professor Mantelero, was actually the expert who worked with the committee on the guidelines on AI and data protection that were just adopted in January before Data Protection Day, so it was on the 25th of January. The texts the text of the guidelines are in the notebook. And then the latest sectoral text, which was just adopted yesterday by the Committee of Ministers, so you don't have it in your folders, but you can find it online, is the recommendation on health-related data. It's a revision actually of a 1997 instrument, brought back in light of the evolution of technologies and processing in the public health sector. So this is just to give you examples of sectoral work that is being done, but the variety of topics covered by the committee is huge, because once again we have public sector and private sector processing that is being covered by the convention. One last word to point your attention to the Handbook on European Data Protection Law that was published for the first time in 2014 with the Fundamental Rights Agency, and which was revised last year to cover the changes of those new legal systems, both at EU level and Council of Europe level with the new convention. And there, in this handbook, which is accessible online, you find both the instruments, but also the case law of both courts, Luxembourg and Strasbourg. So it's a very exhaustive and complete document for legal professionals wanting to know more about European data protection law. So I'm finished with my presentation, and I'll be happy to respond later to questions. Thank you very much.